the election petition, conduct a survey, a public, survey, a poll of perceptions of independence of judges, the judges on that particular panel, all right? And I'm sure there will be empirical, there will be responses that point to the fact that people perceive that the judges were not being independent, okay? Because, just look at how the justices dealt with the petitioner's case, from the beginning to the end, all right? You can, I don't want us to go into the legal merits of that. What is, for instance, wrong, in allowing interrogatories to be administered, okay? For instance, to the Electoral Commission, okay? What is particularly wrong in allowing the Electoral Commission, to answer a notice to admit facts and so on and so forth, all right? The fact that the notice to admit facts was filed and served on the petitioner and the court went silent on it, is itself very telling about the independence of the judiciary. And you can draw irresistible inferences from the conduct of the case about the independence of the judges. And I'm entitled to that view. That is a view that I have taken. My challenge to you is, so if they're not judicially independent, somebody must be interfering, and who is? Because he said you cannot raise that question without proving that there's somebody interfering. Look, I don't want to, I already got into a lot of trouble speaking after the court matter. I don't want to be quoted as having said that somebody was manipulating the Ghanaian judges behind the scenes. I have made my point sufficiently clear that you could draw inferences from the way the justices handled the matter that they were not being independent. That is a position that I'm ready to take publicly.
And that's Dominic Ayine, former Deputy Attorney General. He's Member of Parliament. And after those comments at a program organized by the CDD together with the Faculty of Law of the Kwame Nkrumah University of Science and Technology and another, a program to discuss how Supreme Courts in the Africa region or West African region have been handling election petitions. And so there were guests from other African countries. One of the guests on that show on that day is here with us, Yao Opong. Thank you for making time to join us.
Good to be here.
Right. Now, after that statement, just on the 25th of May 2021, the Judicial Secretary, Justice Cynthia Pamela Addo, wrote a petition to the chairman of the Disciplinary Committee, General Legal Counsel. Who is the chairman of the Disciplinary Committee, Yao?
I think it could be Justice Bafuboni.
It could be Justice Bafuboni?
I think so.
Okay, right. But the CJ chairs the council,
yes,
not the...
It's not a member of
the Disciplinary Committee. You may have heard elsewhere that he's chairman of the Disciplinary Committee. So, the petition says, I read, petition to investigate statements allegedly made by Dominic Ayine. The attention of His Lordship, the Chief Justice, has been drawn to statements allegedly made by Dr. Dominic Ayine during a panel discussion on presidential election petitions and their impact on Africa's democracy. During this discussion, Dr. Ayine questioned the independence of the judiciary due to the manner the Supreme Court adjudicated the 2020 election petition. According to him, the Supreme Court's failure to apply the rules of procedure, as well as the consistent and continuous dismissal of the petitioner's applications or reliefs, were the basis of his assertion. These comments are made against the backdrop of the Supreme Court discharging Dr. Ayine on a charge of contempt for similar comments made against members of the Supreme Court during the election petition hearing. Dr. Ayine apologized profusely when he appeared before the court on the contempt charge and admitted to having made comments which were unbecoming of a lawyer of his standing and a former Deputy Attorney General. His Lordship, the Chief Justice, therefore, finds his alleged disparaging comments totally unacceptable and would like you to investigate this matter further. Please find attached a copy of an extract from an article published on myjoyonline.com. Respectfully submitted, Justice Cynthia Pamela Addo, Judicial Secretary. Copied, His Lordship, the Chief Justice. And this drew a lot of commentary, scathing criticism at the Chief Justice, including from these gentlemen. Listen to them.
Ghana Bar cannot offer a personal unflattering opinion of the judiciary on an academic, a civil society, or other public discussion platform, even after a case has been decided, without risking being hauled before the disciplinary committee of the General Legal Council. Really? On the same platform where this lawyer expressed the opinion that has earned him an invitation to appear before the disciplinary committee of the legal professions regulator, other panelists, including other lawyers, strongly disagreed with him in his opinion of the judiciary regarding the case under discussion, with some praising the court's handling of the matter. In other words, the platform on which the lawyer spoke was a veritable marketplace of ideas and opinion, with panelists debating each other in frank open dialogue. It cannot be okay for a lawyer to praise a court, but an act bordering on professional misconduct for another lawyer to express a contrary view of the court. This, incidentally, was a webinar discussion organized by CDD Ghana in collaboration with the KNUST Law Faculty as part of a new judicial review series, a partnership between CDD and two law faculties in Ghana that aims to review and examine discussions of the court for their impact on democracy and good governance. This particular panel, which examined the recent Ghana election petition through a comparative lens, featured two foreign participants from Kenya and Zimbabwe, 4 Ghanaian lawyers, and me. That an opinion expressed at such a forum to contestation from other participants would cause anyone to lodge a formal complaint with the disciplinary committee of the General Legal Council is unprecedented, bizarre, and ill-advised. Not only is this bound to have a chilling effect on the free speech rights of lawyers, it will also impact negatively on both academic freedom and the freedom and ability of civil society to promote judicial accountability, including through projects like the Judicial Review Series. I find no justification whatsoever for the disciplinary committee of the GLC to be brought into this matter or to investigate Dr. Dominic Akurutinga Ayine for the opinion he expressed on the panel. The Dankwa Institute organized a workshop on the 2012 election petition where speakers such as Sam Okujeto, Professor Frimpong, etc. discussed and criticized the judgment. I supported the Institute in doing so then and still do. I wrote many commentaries criticizing the judgment, including the contempt proceedings even while the trial was still ongoing, incurring the displeasure of Justice Atuguba. Others, many lawyers included, openly and vigorously questioned aspects of the judgment and raised issues about the independence of the judiciary. Nobody, to my knowledge, was referred to the GLC for investigation, and that is right. The judiciary is an arm of government and is not immune from scrutiny and accountability. What then has changed for those who now raise similar questions in the spirit of judicial scrutiny and accountability to be referred to the GLC for investigation and potential disciplinary action? We cannot be free to criticize the judiciary and be quiet when others are stopped from doing the same thing that we are allowed to do. It does not matter whether we agree or disagree with the criticisms. The important thing is that people are free to criticize, and those who disagree with the criticisms are also free to offer their opinions. The needless effort to silence some people in this polity must stop immediately to save the judiciary from itself. Go demands the immediate and unconditional cessation of any and all investigations commenced by the GLC, flowing referrals made by the Judicial Secretary on commentaries made about the 2020 election petition. Dr. Dominic Akurutinga Ayine, stay strong, my brother. Facial expressions and opinion must never be frowned upon in a free society. This is not right.
So those were statements, lengthy statements, with the exception of Kofi Bentle's, by first Professor H. Kwesi Prempeh, disagreeing with the referral of Dr. Ayine for discipline, and then Professor Stephen Kweku Asare also disagreeing looking at the issue even beyond just the invitation of Dr. Ayine. So let's begin with Professor Kwaku Asare. Why do you say what you say in your statement? What's wrong with the Chief Justice finding a lawyer who has been a leader of the bar to have made statements that suggest or border on professional misconduct?
Well, Samson, let me state that I was quite surprised by the referral because I thought it was fairly established in our polity that after a court has rendered a judgment, that judgment is subject to all forms of scrutiny. And this is what happened here. It was at a CDD forum, and it is interesting because I recalled a similar CDD forum where I was a speaker and I used select cases to demonstrate that our judiciary is inefficient. Their jurisprudential orientation is all over the place. Most of their reasoning sometimes are very hard to explain. I suggested that even the act of allowing somebody to choose the panel that will sit on particular cases itself compromises independence, judicial independence. And I bring that up because that event was chaired by Justice Modibo Okran. And I want to quote what he said after my presentation. He said that he welcomes the criticisms of the judiciary, and he explained that such criticisms are necessary to wake the judiciary up and to better, so that they will be better placed to serve Ghanaians. That was a Supreme Court justice. That was not the only time I was invited as a speaker that was chaired by someone from the Supreme Court. Help Law organized another series like that, and I was invited. And the chairman at that time was Justice Doche. I think, Samson, if I recall, you were there.
I moderated it.
I expressed my opinions and disappointments in the Supreme Court and their judgments. And Justice Doche, he said, well, most of what I'm saying, he cannot argue with. And then Ghana at 50, I think University of Ghana put together some workshop, and I was invited somewhere in Labadi, one of those glitzy hotels. I gave a presentation, and it was chaired by Justice Adira. Justice Adira said, Prof, hey, oh, chapeau. She wasn't upset because I was criticizing the judiciary. After the 2012 election petition, the Dankwa Institute put together a workshop, and several people, Samo Kujeto, Professor Frimpong, and so on, they were there to critique the decision. Many of the criticisms quite harsh, but that's okay. That is part of the judicial accountability that the Constitution itself wants us to engage in, because if we cannot criticize and we cannot offer opinions on judgments written by courts, then basically they have become some dictators, and basically they are not accountable to anyone. The Constitution did not anticipate that kind of arrangement at all. In fact, some of the harshest criticism of judges come from judges themselves in dissent. When you read opinions where some judges are dissenting, they sometimes say the majority is irrational. The majority ignores precedents. The majority is out of their depth on this matter. So criticism is a treasured aspect of the legal profession. And to be blunt, I think the referral is unprecedented, unnecessary, unfortunate, unwise, and quite frankly, unjust. It feeds into the narrative that the culture of silence is back. And I don't share the perspective that the culture of silence is back. I share the perspective that the culture of silence never left. It has been with us. It didn't go anywhere and it's back. It's always been with us. Especially when such a referral is made and you don't hear anything from the GBA, Ghana Bar Association. You don't hear anything, and I'm not talking about individual lecturers, but a unified response from the legal academy saying, no, we wouldn't allow this to happen because as academics, we want to be free and we want to say whatever we want about opinions of judges. And it is important to note that nowhere in its statement did Mr. Ayine claim to be in possession of objectively verifiable facts that the judiciary is lacks independence. Rather, what he did was to express a subjective view, an interpretation, a theory, a conjecture. He surmised. I mean, these type of surmises are not even actionable in court. It's somebody's opinion. If you talk to 10 million Ghanaians on the election petition, you are going to get 10 million opinions. Are we then going to refer 10 million Ghanaians to the General Legal Council to investigate? And look at the letter that was written by the Judicial Secretary. Look, the disciplinary process is extremely serious because it imposes cost on whoever is sent there. You have to defend yourself, and potentially you could be suspended, you could be disbarred, you could be reprimanded, you could be asked to offer an apology. And think about the composition of the General Legal Council Disciplinary Committee. It's chaired by Justice Bafuboni, and I believe another justice of the Supreme Court sits on that. And there's a member from the Court of Appeal and 4 other members. It is extremely difficult, or you put them in a very difficult situation to have to say, well, we think the Chief Justice is wrong in referring this matter to us. And look, the 7 people don't try the case. There's a process. And the process is said that they invite whoever has been sent there to write a statement. The statement goes back to whoever is referring. If the committee establishes a prima facie case, then they set up a 3-person committee to do additional investigation. But why impose such cost on somebody merely because that person has expressed a subjective opinion? A subjective opinion that, frankly, is held by many people, whether wrongly or whether rightly. I think the Chief Justice, and I like the Chief Justice a lot because, I mean, he's a very nice guy when you see him in court, and he's also from Commonwealth Hall. And so it's very difficult for me to say things about him. I always want to say pleasant things about him. But on this occasion, he got it so wrong, and the invitation is so bizarre that when you read it, he doesn't even tell you what rule in LI, is it LI 613, your professional code of ethics? What particular rule has been violated? You said because the Chief Justice is unhappy, or some words to that effect. What was the term that he used? So
I will shortly show you some portions of the new LI, and we can make a decision whether or not, it can assist the discussion whether or not Dominic Ayine will be in violation of his professional code. But, You refer to Sam Okudzeto.
Very quickly. Let me land. He says that CJ finds his alleged disparaging comments totally unacceptable. I mean, is that in your rule that anytime the Chief Justice finds your disparaging comments to be totally unacceptable, you can be sent to the General Legal Counsel for investigation? We are lawyers, and we have to understand that we deal with rules, we deal with regulations, we deal with law.
So quickly, let me have your quick response to
violating Rule X1D, so that people will know. The people can read it on themselves.
Let me have your quick response to this. Let me have your quick response to this, because you refer to Sam Okudzeto and others passing, making commentary on the 2012 petition judgment. And what he said essentially was that he found that he was confused about how the ruling had gone, the judgment had gone. But from his reading, he found that it was rather the petitioners that had won and not John Mahama. And then he made comments including saying this: Bafuboni, quote, Bafuboni didn't give any figures. So how did he come by his decision on dismissing overvoting? And he questioned, is this the same as what you may have heard Dominic Ayine say? Not long ago, 2019, a former director of the Ghana School of Law, Kweku Ansah-Sari, was also hauled before the same disciplinary body for making comments including what he said he accused the GLC of perpetrating, quote, perpetrating fraud and deliberately limiting the number of students to be admitted into the law school, unquote. In fact, he said a number of unpalatable stuff about the Chief Justice. He appeared and then defended himself. He said he cannot be cowed. He's a bold lawyer. Nobody can cow him. What do you say? Why is it different now?
It's different because we are basically going backwards or going forward in reverse. We transitioned from one regime where one could not talk, and 25 years after experimenting with a system that asks us to talk, people are now being asked to go and explain why they have indeed spoken. And you mentioned what Sam Okudzeto said and what he said about Bafuboni and so on. Now it comes to how elegant are you in saying that the judiciary is not independent. So you can say, well, I don't know where they got their numbers from. And then don't land by saying, I think they are not independent, because no independent-minded person will reach that conclusion. I mean, we are clever enough to say that the judiciary is not independent by using different language. And what you are going to be doing then is to punish people who lack the elegance to state that the judiciary is XYZ relative to people who are sophisticated in the use of the language and can say the judiciary is not independent and so on. The Chief Justice should chill. Basically, remember, we are just 2 months or so away from that edict that he issued that the media should pull down all harsh criticisms of the courts, and that majority of the people are illiterate and uneducated and should not be exposed to these types of harsh criticisms. In most jurisdictions, that would have created all kinds of commissions and maybe even some resignations. But they got away with it, and it hasn't ended, and they are pursuing that same thing, that same direction. Here is what I think the judiciary should do. Number one, it should just focus on doing its job according to their oath. If they make decisions based on the facts and the law, no amount of criticisms leveled against them will be accepted by majority of the people. On the other hand, they can send everyone to jail, and that will not stop people from questioning their independence.
Okay.
The problem we have, Samson, is one, many of their decisions are poorly reasoned. If you read Ayine versus Attorney General, and I'm using Ayine versus Attorney General because Ayine is the one we are talking about, no reasonable person can come from reading that judgment and conclude that the court is doing something right. That decision was so flawed that we should forget having celebrations about Ri Akoto and start discussing Ri Ayine. Second, the court is not, in most cases where time is sensitive, making timely decisions. A good example of that is that Auditor General case. I was involved in that and I've even withdrawn because I don't think the court is serious. The third instance is sometimes the court gets it wrong, and when people point it out, even using the judicial process, they try to intimidate them by imposing costs. For instance, I had a case at the Supreme Court claiming that the Ghana School of Law is a monopoly, which violates Article 25(2). The court, in an opinion, bizarre opinion, claimed it lacked jurisdiction. And if you read that decision, I want everyone to go and read that decision. It's so flawed because they fail to understand what Article 2(1) is saying about standing. And they cite an NDC case, which has nothing to do with what I was bringing about, which was there was a regulation that violated the Constitution. So, I filed for a review, and when I filed for a review, I haven't seen the opinion, but my attorney tells me they imposed a cost of 10,000 cedis. I mean, I am involved in a constitutional case. You've got it wrong, and you want me to pay 10,000 cedis.
Okay.
What you're doing by that is inviting me to be in contempt of the court.
Okay. Thank you. But when you disagree with them, you say they got it wrong. That's also language. Now, Oliver, you also wrote and looked at it beyond just what is happening. You, for example, I've seen you refer to the matter in which Francis Xavier Sosu, went to the committee and lost his license to practice for 3 years, and then he went to the court and got this same judge, whose ruling we discussed a while ago, Gifty J. Ado, to reverse the decision of the General Legal Council and ask him to go back and practice his law. You refer to Sam Okudjeto's comments on that case. He said, among other things, quote, "Sometimes some of them don't understand because a high court judge purporting to overturn a decision of a disciplinary committee, forgetting that on the committee you had 3 Supreme Court judges." Then, among others, he said, "What makes you, the high court judge, think that you understand the legal issues more than the Supreme Court judges taking the decision?" How do you use this, to juxtapose what Dominic Ayine said and to say he shouldn't be invited?
Thank you, Samson. I think for me, outside of a lot of the comments that Professor Sari has made, which so many of them I share the same sentiments, is that we need to also reflect on the structural questions between how the powers the court is exercising vis-a-vis dissent and how it situates in our body politic generally. The first one is the relationship between the General Legal Council and the Supreme Court, which for me, nothing grounds it much more than these comments that Sam Okudjeto, former president of the bar, made regarding the fact that there were 3 justices of the Supreme Court on it, and how dare a high court judge even overrule that decision. And it translates for me the relationship that needs to be scrutinized between the council and the disciplinary process and the Supreme Court, which could be perceived to be using the disciplinary process as a way to seek and address personal vendetta. Because even if judges properly seize of their own jurisdiction cannot go against the disciplinary process, then we have a certain view of the judicial process, is that it's a process by which the courts do what they want to do. I'll give another example to substantiate this. Many years ago, I was a mere researcher at the Constitution Review Commission, and Professor Raymond Atuguba then had been invited on a panel by the NCC to give certain reflections about the judiciary. And I've been, as a young person, helped in putting together his comments when he went before that process. And he said, and his words were very categorical, that from his own experience having lived with a judge, nobody can convince him that Ghanaian judges are not corrupt, or at the very least, Ghanaians do not try to bribe their judges. Because he had seen instances where people had come before the judge to try to bribe the judge. These comments were then translated by the Supreme Court as a basis, one, to refer him to a disciplinary hearing process, to refuse to grant him audience before the court, he himself, and even the late Larry Bimi, who was chair of the NCCE, that they would not grant them audiences before the court at all. For me, it raises substantive questions about who is policing what the judges do and the ways in which they can even use powers to abuse the powers and nothing can be done, because we have a constitutional framework that sets them as the guardians of our constitutional values. And when they step out of line in acting in ways in which would not be in consonance with the Constitution, we have in fact no remedy. And beyond refusing to grant us audience before the court, they can then go and invoke a disciplinary process that it is perceived widely within the profession that once they act, no other judge should have authority to even consider overruling it. So that's the first structural issues we need to interrogate. The second one, I would say, is the relationship between the judiciary and parliament. And now, so many people have asked, for instance, why did Ayine apologize in the first instance? But the same question arises, and I think we've discussed this on this same platform, regarding why Montaka then refused to press the question about allegations about a certain judge who had called a member of parliament. Because I do think that in the way in which the branches relate, that certain branches have decided that they were going to give certain deference. And because of that deference that they want to pay to the court, they would rather not press certain things to their full conclusion. And even I disagreed with Muntaka on that particular case, saying that our democracy was poorer for the decision not to press that issue. But it seems, for right or wrong, that the parliament has decided that for its own purposes, whenever issues that could be confrontational with the courts arise, it will advise itself and take a differential approach. It doesn't seem to me that the court is continuing in the same manner, and viewing that where it is exercising powers that may bring it in clash with parliament, it must exercise some level of differential attitude. So we saw it drag Ayine before them, who is a member of parliament. We've seen them now again try to invoke a disciplinary process against a member of parliament. I think these issues we need to interrogate, and even parliament itself must be awake to its powers to call the judiciary to heel in the same regard. But I want to make certain general comments, and if you would allow me. I think, first of all, for me, this whole thing, I take inspiration from the good book, which says in 1 Corinthians, I think chapter 6, verse 12, that all things are lawful, but not all things are helpful. That all things are lawful, but not all things edify. I do not think that in pursuing this, and so many people have said that the judiciary has been minded, or the Chief Justice in this particular case, has been minded by the strong words that the Bible advises. That you may think that you have a particular right, but the question has to be whether these things are helpful. In this particular context, we need to also remember that the judiciary is like any of the other co-equal branches of government, and that it is a political institution. Its role, its mandate, how it discharges that role and mandate, form part of a political process. And that in the normal political process, it is subject to critique, debate, analysis. The judicial power itself is nothing but political power inherently. But for some inexplicable reason, the Fourth Republican Court in particular has become more and more brazenly autocratic in the ways in which it relates to dissent and criticism of the court. For me, I think it offends justice for the courts to become so sensitive and fragile that they perceive just about any criticism as undermining them. And perhaps it's for these reasons that I kind of want to even, spend a little more time, if you allow me, on the colonial origins of the power, some of the powers the court continue to assert. Because I think the institutional habit to demand rather than command respect is a colonial inheritance. And our courts seem to have developed a discomfortly, familiar standard in relation to the exercise or how they view criticism of the judiciary. So when you take the disciplinary process and even the contempt powers generally in context, these were powers which were asserted by courts in pre-medieval times in England because they were viewed as equivalent to the lèse majesté rules by which nobody could speak ill of the king or that the king was literally perceived as incapable of doing wrong. Now, because the courts sprang from the monarchy, it was considered that any criticism of the courts was an insult to the king himself. So that is the genesis of the power. And it's the power that the Supreme Court is often uncritical supporters are telling us that it must continue to have a place in our established democracy. I think not. I mean, I've talked about MPP versus Attorney General, which for me remains one of my most favorite judgments, where Amwaseji says the medieval fiction that the king can do no wrong has no place in a republican setting. So it seems almost surreal and an exercise in cognitive dissonance for me to tell me that the courts, whose whole function and sole purpose is to fulfill the law, would seek to step into the role of the medieval king and assert that any criticism, and it has the sole authority to determine whether criticism of it is valid or invalid. And it's even best reminding that even in England, where the power originated from, contempt ex fasciculi is completely annihilated. It does not exist. But even when it did not exist, they in the colonies, Ghana included, continue to assert, and this is one of the Privy Council decisions. I think law students can go and look at McLeod versus St. Aubin, where the court said that we need to keep these rules around contempt in the primitive societies in the colonies, because the officers of the crown would come up against uncivilized brutes. We saw the same kind of language being rephrased in the letter that the judicial service has called to be issued to media houses, where they were commenting and talking about how the general public were not sufficiently educated as to be able to comment on the court. I think this, when a lot of people are expressing frustrations about how the court is going on and expressing some level of fragility, this is where people have a lot of concern about.
Okay, so Professor Kukwasari had asked a question, and I want to refer you to just two provisions of the new Professional Code of Ethics. That is LI 2423/2020, and ask whether you think that will not ground a basis, at least for the invitation of Dominic Ayine before the disciplinary council of the disciplinary committee of the General Legal Council. So look at 52. 52 says a lawyer, it's headed Statement about Judicial and Legal Officials. It says a lawyer shall not make a statement which the lawyer knows to be false or with reckless disregard for its truth or falsity concerning the qualification or integrity of a judge, an adjudicative officer, a public legal officer, or a candidate for election or appointment to a judicial or legal office. So if you isolated that of integrity of a judge, what will you say about the invitation? And then look at 90. 90 is on improper communication. It says a lawyer commits professional misconduct if the lawyer, in the course of practice, communicates to a client, another lawyer, or any other person in a manner which is abusive, offensive, or otherwise inconsistent with the proper ethics of the professional communication from a lawyer. Clearly, 90 may not apply. But what do you say about 52?
52 is factual. You make a statement knowing it to be false. And that's what I said. For an action in defamation to be even actionable, you have to express a fact that you are in possession of objectively verifiable facts that some member of the Supreme Court lack independence in this case. If you do that and you don't have the facts, then you are in violation, or you may be in violation of 52. But 52 does not say, you cannot say, I believe, or based on this, I infer. No, these are opinions.
Will that amount to making a comment with reckless disregard to the integrity of a judge?
No. He's basically saying, for instance, the civil procedure, the election procedure manual says there should be a discovery period. There was no discovery period. Therefore, I think the judges did not follow the civil procedure or the election procedure, and therefore they had a predetermined agenda, or they are not independent, and so on. That is his opinion. If you call 50 other lawyers, they would disagree, or some of them would agree. That's fine. That's the nature of our business. That's the nature of legal academy. People write opinions all the time. University of Ghana Law Journal, I wrote an article about Ayine versus Attorney General. Some other lawyer can write an opinion disagreeing completely with everything that I said. That is fine. That's my opinion. That's his opinion.
Okay.
But the fact that you are going to criminalize opinion, that has no basis at all.
Thank you.
In what you read.
Oliver, let's hear you 1 minute on this before I come to Yao and then Kwekubako.
Personally, I think that there's no basis to say that an opinion, once expressed, must explicitly demonstrated to be false. I'll give you an example. I think the courts, and our courts in general, the Supreme Court in particular, is biased in favor of establishment. And I say this, and I can refer you to Dr. Ben's judgment in Rascon France 3 versus Attorney General, where he said the only reason why he was not allowing the claim because it would lead to a nuclear meltdown, because so many of our public officers have been doing the wrong thing for so long. That is a bias expressed in favor of the establishment and the status quo. To say that it's based on an opinion and a reading of the cases. He did not, Ayine, as I understood in the statement that was played, did not go on and say that the judges have been compromised by certain persons, whether in the executive or anywhere else, or anybody has been paid in any particular manner. But you must also remember that allegations of bias are part of the legal process. And that even in our courts, you can't go before the judge and say that, I think you'll be biased for XYZ reasons. Salah, the Attorney General, for instance, it was said that because of the personal friendship relationship that the judge might have had with one of the parties, the judge was biased. So allegations of bias are not out of this world or pedestrian, that they can be made whether within the context of the court or outside of the court. And I think this is one of the questions we are dealing with, and I do not think sufficient grounds are established to say that the statement which he made based on an opinion of his reading of the judgment was false.
Okay.
Last point before you go.
Yeah.
Last point.
Yeah. No, I needed you on this. Keep the last point. Don't forget it. Are you, by any stretch of that argument, suggesting that as a professional body, we don't need these rules that are supposed to bind us?
Oh, no. I think we absolutely need those rules. The question is not whether or not the rules exist, but how they are applied and the ways in which we read the rules. Because I do think, and I've said before, even in the contempt proceedings against Ayine and other lawyers, I said that lawyers for themselves have chosen for themselves certain professional standards. That once a case is ongoing before a court, and if you're appearing before the court, you would not comment on that. Those are rules of their own profession that they abide by. I think those rules are valid. But the existence of the rules itself do not imply that they are being correctly applied in every instance.
Okay.
And that's why I started with the biblical quote, saying all things are lawful, but not all things are helpful.
Okay, so go to the final point you wanted to make.
The last point, in contentious political cases as an election petition, I think that the judges must understand their role very carefully and the comments they make. You could take, for instance, the Chief Justice comments in the previous one that was brought against former President Mahama, where he had substantive grief with the fact that the EC refused to admit certain evidences. Then you see a complete turnaround in this case. It grounds people without explaining why he has taken a different position. I think those are even questions of law to ask, but why have you changed your position? Is it because the parties are different? To say that doesn't mean that I am accusing the judges of something so nefarious that it scandalizes the court. But based on the judge who has taken a completely different position, where the facts seem similar, but the parties have changed, to explain why they have come to a different view, it only reinforces belief in the judicial process. I mean, Supreme Court Justice Louis Brandeis once said, if you desire respect for the law, you must first make the law respectable. And I think the failure to clarify when we take different positions, depending on different parties, knowing the political nature of the cases we are called to intervene on, can lead to certain accusations. And I think those are fair.
All right. Now, I followed that discussion. It came just, I think, a week or so after we had gone to the CDD. Kodeo had brought a number of us together at Pram Pram, right, to examine the elections and to proffer views. And I was privileged to speak with Professor Kwesi Prempeh and then also Justice Tokono. Right. Not all of us had sweet words for the judiciary. We had criticism as well, and we were doing our work. The Justice Tokono, in also trying to justify some of the things they did, had all the right to also, give a justification. So Professor Kwesi Prempeh says, in a market of the contest of ideas, opinions, why should one's opinion that suggests that they cannot trust the judges be a matter for discipline? And many lawyers will tell you that going before this body is, they will always say, you are going before the Sahende. You go there and it's not going to be easy. I've appeared before them before though, but it was good.
I cannot see how you'll be active.
Some have not had the best experience, that's true.
Every active lawyer, one day or the other, in fact.
Okay.
Yes, so good to be here. I think you recall that during the discussion, and I was a member of the panel, I didn't know what happened, but as soon as Dr. Ayine made certain statement, he had started delivering his submission, fantastic as usual. But as soon as he said something, I tried to interject. Of course, I was asked to
And
wait.
you say fantastic because you liked what he was saying?
Yes, yes.
I watched you. Immediately he spoke about the independence. You attempted to interject, and we were told to hold on.
Yes.
When he's done, you can
And almost contemporaneously, I said, Dr. Ayine, you are out of order. You are completely out of order. It just came. And before the end of the program, I remember saying that he shouldn't take offense. But that is how what he said hit me. And that was the immediate response that came from me. And of course, I mean, he didn't also say anything to the contrary. So I believe either he stands by it or he didn't think it was necessary to even also respond to me. And I think Mami Mensa Bonsu, I think that's her name.
Yeah.
Also then chip in and question Dr. Ayine and ask him to provide some concrete evidence or suggestions to authenticate what he had said. But that is where then the host also came in, and Dr. Ayine said he has had some problems already in the past. So that's where we are. And I think that the courts have always welcomed criticism. There could be instances where one or two may not entertain that. Anytime we file an appeal, we say we are aggrieved or dissatisfied by the decision. And that in itself is a lawyer criticizing the decision of the court. Because if you cannot criticize the decision of a court, you cannot even file an appeal. Even the omnibus clause that we put in is suggestive of the fact that you think the judge did not consider your facts and the law in a way that the mandate given that judge obligate the judge to do so. So I'll be surprised if any judge will, in a way, find problem with a lawyer who has taken the judge's decision and is critiquing it. So our favorite case, and I think Uncle Kwaku remember, probably versus Mensa Bonsu, and the declaration that Adade made, which in discussing matters like this, I always want to also remind myself. And he says that I would wish to caution that we all, the lay public, the legal profession, and the judges themselves, have a stake in upholding the integrity authority, and respect of and for the judiciary. If these should collapse, one of the surest foundations of our democracy would have vanished, and we shall all be the poorer for it. Of course, judges, like any other group of human beings, do make mistakes and should, and indeed ought to be criticized. At times, some of us feel that our judgments are not criticized enough, especially by the legal profession. I expect, however, that the language of criticism will be tempered and measured. It is not often remembered that judges, seen by many as very strong, are in fact the weakest members in the society. We receive blows. We cannot throw any. A factor to be taken into account when a member of the public is inclined to criticize us. So, and this has been true before the 1995-96 when it was made, and even so more applicable today because of a lot of things that have happened, because we are deepening our democracy. So I think that it is not about any person having an aversion to criticism. Perhaps, and what we are doing now also shows that if Dr. Ayine still stands by what he said, he will be able to defend it, and even if he's ruled against, Sosu's own, Honorable Sosu's case, shows that a high court judge has jurisdiction to either set it aside or vary it. Another one also went on appeal. The Court of Appeal also varied at least the sentence or the, if you like, the punishment. So I believe that, and I've made the point, that if Dr. Ayine were to be given another opportunity, he may definitely not have used those exact words. Perhaps he will continue to be unhappy about the decision, and there's nothing wrong with it.
The thrust of what he said, what about it that is sinful? That I have been put in a place where I cannot trust them for their decisions. I cannot trust them for their independence. Is that the cardinal sin?
Well, it may not be a cardinal sin, but of course, I mean, at first point, you may feel that. One, to, I won't say accuse, but to state that the Supreme Court judges who sat on the presidential election petition were, you have information, or based on
faith.
what?
You have lost faith in their independence.
Yes. Well, not in so much that they are not independent because of the fact that, one, they gave rulings without reasoning, and they, in his view, they violated or did not apply some settled rules and practice.
Or were unanimous in their decisions.
I think that all these statements are fair, but perhaps it's the inference that he drew from these observations that he has made that may be the subject of this invitation.
I have said, and in some of these fora that we give our views on, I have said that my candid view, after a thorough legal reading or reading with a legal eye of the judgment, there can be a reason for the dispatch at which these applications were being dismissed and being dismissed unanimously. And my view has been that they were unmeritorious. They were so poor and so were deserving of being dispatched unanimously because the others could not know, somebody could not have dissented from my view.
That's right.
If that is okay for the judges, why should they feel offended by someone having problem with it?
No, but I'm saying that if Dr. Ayine said something similar to what you have just said, in the opposite way, that he had a problem with they not applying what he, quote unquote, or in my view, he referred to the settled practice and the rules, applicable rules. That is fair. And I'm saying that perhaps it is the inference that led me instantly to say that he was out of order. The inference that because of these, because the judges have held in a number of cases that if a judge can be right, the judge can also be wrong. And that is it. Perhaps it's unfortunate that that is the final court. But if it had been a court of appeal decision, for example, and you go, or high court, you go for certiorari, they will ask you, is your problem with the fact that the judge was wrong, or that the judge violated some of the well-known grounds on which certiorari can be founded? And if it was only about the fact that the judge was wrong, then they will quote this to you, that if a judge has the jurisdiction to be right, then the judge also has jurisdiction to be wrong. And the remedy is appeal. You understand? So you can say that the judge was wrong, in your view, in your analysis. But to say that perhaps, well, that may be evidence of
lack of independence.
That, for me, is what may have led me to erupt, if you like.
There are some people who are asking this question. If you went to the presidency, Republic of Ghana, that's the communication bureau. If you went there and you check up a story, 20th August 2019, it's headed, Amended Mining Act, proffers stiffer punishment for illegal miners, President Akufo-Addo. Then, after he says a number of things, he comes to this place, and this is the presidency writing about what the president says. According to the president, then they quote. So this is the president speaking. We felt that we have to take away some of the discretion of the judges. It is unfortunate that it should be so, because all of us should be able to trust them to do their bit in stamping out crime and its consequences in our society. But that doesn't turn out to be the case. Then he continues. How is this different from saying, I don't trust in their independence?
Well, this is the point is that this is not for me to really determine whether this or that is. And I'm saying that even in putting it that I don't trust your independence, I think that is even milder. But the definite statement about lack of independence may also be another. And so it is for Dr. Ayine, as I keep on saying, if he still stands by it, these men and women, very eminent personalities on the committee, definitely know. Of course, I think there's usually one or two who are supposed to be non-lawyers, but definitely know what they are about. It is an invitation, all right, of course, all the kind of aura that we all know surrounding it's also there. But previously, there was a communication that 3 of our colleagues were also sent there recently, bordering on similar matters. 1 or 2 putting a plea for them. And
Bar Association people.
Yes, and it truncated. And
is that a process of justice, that you are going to look into misconduct of some lawyers that you have invited for commenting on the petition, and then the bar president or 1 or 2 other people come in and say, oh, let it end there, and then it actually ends, they are forgiving?
Oh, well, I mean,
that's not a justice.
No, if by withdrawing a statement you have made for which you have been cited for contempt, will convince the court not to even continue with the hearing, the proceeding, and ask you to go home. Not even to hear the matter, and ask you to go home. That should also tell you that these are not personalities that just are happy to perhaps invite people and just to ensure that, for example, they curtail their right to speak or how to practice their profession. So that you go there and you are entitled to all the facilities that any other person. But, I mean, to be honest with you, it's not something that one relishes.
Right.
You would have wished that.
and I know why he says it's not something, it's not a place that one relishes to go. And let's bring in Kweku. And he speaks perhaps from experience or from what other lawyers say. I say that is not my experience. I had a case, and the lawyer involved decided rather to abandon the case itself and then instigate the people to take me there on a very frivolous claim. So when I was going, I heard people say, you must go there with a senior lawyer, a very old lawyer. I said, as far as I know my case and the facts I have put before them, I don't need anybody to follow me. So I went there. Yeah. I went there alone. And when I went there, Justice Aniyabwa was in the chair. Exactly. And I didn't have the experience that people have spoken about. Yes. But it gives you an idea why people feel that place is the slaughter, so to speak. Yes, Kweku.
You know, I'm not too sure. You are the lawyers. In terms of the nature of this case, I hear people say unprecedented. Mm-hmm. Perhaps because, and that's why you have to alert me if I'm wrong, this appears to be coming from the Chief Justice or his office through the Judicial Secretary, if you read the letter. Yeah. Reference to the General Legal Counsel. Am I right? Mm-hmm. Yes. You recall that, and the gentleman on the Zoom is a Baker.
Mm. Yes, Baker.
He referred
Oliver, easily.
The Raymond Atuguba and David Annan, Larry Bimi, and I think Amaliba Ibrahim case. Mm. That was triggered by the Association of Magistrates and Judges. It was relative to some comments about corruption and things in the judiciary. But I remember also Gabi Ochredakun and Chachu Chikata post the 2012 election petition hearing. The Ghana Bar Association referred some comments they made and their conduct in that respect to the General Legal Counsel. I don't know if you remember that. Mm. Their comments were relative to the outcome of the election petition. That's why I say it may not be exactly unprecedented unless we are talking of the sources that triggered it. I'm not aware of an earlier one may be triggered by the Chief Justice. You may have to.
Oh, no, it's not the first time, honestly.
So there are many examples.
It's not the first time.
So we cannot be talking of unprecedented in terms of the nature of this case. Eventually, I'm told that Gabi and Chachu's case, it went all right to the General Legal Counsel, but it was not determined because the same judges who were on the panel for that election campaign decided that, look, don't proceed, just what you discussed, because it will further polarize the country after the election petition had seemingly polarized the country.
If a thing is right and has to be done, you do it. Why do you make a consideration of polarization?
Yes, I'm not supporting it. I'm just recollecting that precedent, because you just asked him some questions,
right,
and that tells me that similar things had happened. But I'm not justifying it. I am saying that.
Oh, I'm not suggesting that. Not in the remotest.
Yeah, you know, there are people who don't listen to some of us carefully. They do selective listening and hearing, and then make judgments on what they hear. But the point I'm making is that we've had situations where references of commitments, comments and things have been made to the General Legal Counsel. We haven't had very serious solutions to it. In fact, even the Amaliba one, or the one, I'm not sure it was finally determined. What happened at one stage, Raymond Atuguba appeared before a case. I think, is it the Brebre case?
Yeah.
Yes, and the court...
Bill
case. And the court adjourned and said, look, go and purge yourself of that allegation before we sit. That happened, but I'm not sure if the 4 lawyers in that case were properly dealt with by the General Legal Counsel. Now, let me tell you something, my own feeling about Dr. Ayine's thing. The forum, Judicial Dialogue Review Series, that's the forum. Gabi's was a Facebook wall post. The Chachushikata was a TV interview with my friend Pratt on Hot Issues, TV3. This forum, I think, is an appropriate forum that should enable and allow criticism of any judicial pronouncement or verdict. And I think within that context, I'm prepared to be charitable, liberal, and accommodating. That perhaps the CJ's thing is an overkill, in my candid opinion. Especially when I hear that there were people who counted some of the things he said, unless that's not factual.
No, that's true.
Yes. So here was a situation where it was a give and take, judicial decisions being subjected to criticism, which is normal, constructive. Generally speaking, I think we should be able to accommodate that situation and allow it to pass. The only difficulty I have, and I think Dr. Ayine should also have a reflect upon, what he was saying, the little we saw here, was similar, almost the same, like the things that took him to the Supreme Court. You know my position on contempt. I don't like it. That animal is not an animal I'm in love with.
An aspect of it, scandalizing the court, you may not like that. But the other part, which will make sure people don't misbehave, even when you get a judgment, they can misbehave.
Wise I see it, what I don't like about it is the custodial sentence that possibly comes with it sometimes. I just don't like it. But the point really is that Dr. Ayine, what was the basis for his apology at the Supreme Court? Was he forced?
No, he had actually written a letter.
Yes,
I saw it before the proceedings.
He's a top lawyer, a former deputy attorney general, a member of parliament. I'm sure the experience he's had has toughened him. He's somebody I like, though. I think he manages himself well, very gentle and all that. But what was the basis for the apology that he rendered to the Supreme Court? Was it out of fear? Was it based on lack of conviction, the courage of conviction? Did he think he was genuinely wrong and so offered an apology?
He said he was genuinely wrong.
Exactly. Yes. If so, what he said...
He said so, but at the back you hear commentary from people, including perhaps Professor Sari, who will say the manner in which they treat contempt. When you go there to try and explain, you are in deeper trouble. So you better go begging.
Yes, so if, you see, that's why I talked about him. He was a former deputy attorney general, a member of parliament, a top lawyer. You found yourself in that situation, and I want to give him the benefit of the doubt that he genuinely realized he had made a mistake. So he offered an unqualified apology to the highest court of the land. Now you go to such a forum where they are doing criticisms and things.
And sorry for interfering, but do you know what they did on that occasion? They struck out everything to the point that there's no record against him.
Yes.
If you and I were hauled for contempt, the record will be there against us.
Yes.
As far as Dominic Ayine is concerned, there's no record against his name that he has suffered anything.
But that shows a kind of authority that is entertaining.
Yes, so go on.
Matters like this.
He goes to this forum, an august forum, very critical platform. There's so many things he could have said and dealt with in a different way without arousing the same reaction. Because it's like a repetition of what he had said that took him to the Supreme Court.
The case is over then.
Oh, but we, the public, we are watching, we are learning, we are studying who he is, we are examining him, we are looking for consistency, coherency, courage of conviction and things. That's what we are looking for. He's no longer at the Supreme Court. That's not where we are judging him. We're here, seated here on such an important platform, and I'm analyzing him. I smell inconsistency. I smell lack of courage of conviction. I smell some fear. That's not what you sell to people to emulate. If you don't believe in something, stick to it. So you gone here, as I say, in principle, I would let it go. I would not believe in what the reference to the General Legal Council. I don't really vote for it. I wish they would terminate this. But honestly, we should also be looking at ourselves. The consistency, the courage of conviction that must accompany your track record is important. You just don't sacrifice it because perhaps this time around I can say it and get away with it. It means perhaps at the Supreme Court you didn't mean it, but you knew that the implications would be dire. So you had to give in and get your freedom. I'm not too comfortable with that kind of profile.
Okay.
And he's a friend. If he's listening to me, that's my verdict on his conduct.
We take a break and then return shortly, but let me mention this, that I have a message that says, I should stress, unlike what Yaopong is claiming, that Dominic Ayine made a definite statement of fact that the judiciary lacks independence. All he said is that the way and manner the Supreme Court ignored settled procedures of law and practice in dismissing the interlocutory applications of the petitioner dampened his hopes about the independence of the court. Okay, I'm not sure you're saying anything different from what we have said, including what Professor Kukwasari has been insisting on. We take a break. I return to read some of your messages and get my guests to make 2 minutes comments each to wrap up this. We are unable to go to the last issue of the national security. Koku is saying next week, but I doubt that the production will want to table that issue any further. We have a footage, I'm sure you may have seen it, where national security is caught on CCTV operatives. They are masked and they are hooded and holding their guns in a certain place, and they now stand accused of actually stealing money from that operation. We'll be right back.
This is an issue that must come back.
You're welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile, we put Ghana first. It's brought to you by Bank of Africa, as strong as a group and close as a partner, MTN everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Duraplast, where Duraplast goes, water flows. Having mosquito spray and coil, pleasant on humans, tough nightmare on insects. And Napa Foods, it is tasty. DBS Industries and Robert & Sons, seeing is believing. Thank you to all my guests for your patience, and I want to say a special apology to Professor Kwesi Ayine. He would have joined us for the very last topic on the national security issue. My production makes me understand that that issue will be discussed next week, God willing. Papa J. Jr. says it appears the judiciary wants to be seen as so powerful that no one should criticize it. Is our democratic system of governance failing us? Nana Opipihene says, unfortunately in Ghana, those in the helm of affairs, especially civil servants who invariably exhibit lackadaisical attitudes, are those who also show I don't care behavior towards work, yet first to demand remuneration aside allowances. Okay. Fritz, McLean, Jones. If criticism has been welcome or been part of the Supreme Court over the years, why now Dr. Ayine being dragged to he's not being dragged to Supreme Court, he's being dragged to Judicial General Legal Council's Disciplinary Committee. Nyavo again says the CJ should be reminded that Ghanaians did not fight the AK-47 only to be silenced by him. Okay. Yaobafo Anderson says Ayine gave his opinion. The Chief Justice says it is not right, so he has referred it to the General Legal Council. A lot of people have criticized the ruling and have not been referred yet. Where from the culture of silence? So let me go to Professor Kukwasari. What will be your closing comments on this subject matter in some 1 minute?
Well, I want to close by going back to what my friend Kokubaku was saying. He raised questions about fear, about lack of courage, about inconsistency relating to Dr. Ayine. I don't think that is the proper inquiry. The proper inquiry is, why is it that Ghanaians generally are afraid to express their opinion? Why the inconsistency? Why the lack of courage? This is the same thing Sam Jonah raised, the culture of silence. But why? What is the source of the culture of silence? When Ayine profess his opinion and he's invited to the General Legal Council, it's not only Ayine who is being silenced, it's the 2,000 people who draw the proper inference that, I don't want to go to the General Legal Council, so I'm going to shut up. That is the chilling effect. That is what people like my brother, my good friend Opon, they do not appreciate that. So he says, well, I would have been happy if Ayine had laid all the premises, but did not conclude. What is the point of that? You want him to be, he's inviting him to be basically dishonest about his views. If he strongly believes that independence has suffered, he should be free to say that without being invited to go and explain to anyone. In fact, somebody could take the position that there are so many Supreme Court justices. What was the process of choosing these 7? And then from that, write an academic treatise or academic article on why the selection of justices could be strategically or opportunistically be used to get to some conclusion.
All right. Thank you so very much for making the time. We know that at this time of, is it the night where you are, it has to take a lot of sacrifice to, join us and be part of the discussion. Yes, Oliver, in a minute, what will you say in conclusion? Yes, Oliver.
I think that my concluding remarks would focus on how we protect the judiciary. I find that the biggest problem facing the image of the judiciary and undermining respect for it is not from commentary by academics like myself or civil society like Kwesi Prempeh or even the former Deputy Attorney General and Minister of Justice. You know, when I announced that I was coming on this show to talk about this issue, a former lecturer of mine at the University of Ghana, an intellectual who I respect a lot, wondered if my potential criticism of the court would mean that they would refuse to hear our case, the Face the Country case that we brought before the Supreme Court, which is happening on June 8th. And I think that opinion that somebody would reach that conclusion on the basis of a criticism says a lot about the internal ways in which people process the role of the court. In this country, we have not sufficiently even come to terms with and reflected over the fact that our judges were seen on TV literally taking votes as bribes. That reduces and undermines a population's psyche and belief in the role of the court. How many of those judges were prosecuted? Very few of them, if any. We continue. So how does this country have
but as a matter of fact, the announced investigation has led to all the judges involved having lost their jobs. Correct?
But none of them. But none of them was prosecuted, because it's not only about losing a judge. The way in which we express rejection of it is not trying to cast them as separate and bad apples.
Thank you so very much, Oliver. Thank you so very much. We've run out of time, and I need to make this very important. My outfit, many of you who are talking about my outfit, it's by Habels Couture. And Habels Couture is doing a Father's Day special package. So you get your wonderful dad a beautiful kaftan for as low as 350 Ghana cedis, and they would give you some freebies in addition to that. You can find Habels Couture at Jiringano, opposite Villa David. You can also call them at 020-084-1988. You can look for them on social media using the handle Habels Couture. We've got a couple of seconds to go.
Say that I didn't say that Dr. Ayine shouldn't have made conclusions. I said that perhaps it's the inference he made that is the subject of the invitation.
All right.
And Dr. Ayine can tell you, the first one, some of us were very...
The time is up. The time is up. And today is a very special day. So my producer, Sami Odame, who is celebrating his birthday, says that we should all get ready and enjoy some wache coming from Alaji's wife. Sami Odame, happy birthday. God bless you always.
Happy birthday.
Happy birthday, Sami.
Right. Have a good afternoon.